Hi, everybody. It's Professor King here, Professor Laura King here. And welcome to my amazing lecture and presentation, More Like Copy Wrong. Am I right, ladies? I would like to note that the amount of ladies in attendance tonight is definitely not everybody. And I would like to say, I don't really care. Saying "am I right, boys" and "am I right, non-binary people" doesn't have the right ring to it. And I could have said "ladies" and "gentlemen," but I decided not to because I'm a lady and I get to make the decisions because I'm also the professor. Hey, welcome to the lecture. Today's lecture is about intellectual property. It's going to focus on copyright law because copyright law is the most interesting of intellectual property law. But first, we're going to talk about the different categories of intellectual property. But even before that, we are going to talk about why do we even care about intellectual property? Well, the short answer is that we want we want to encourage artists to make things. And in a system of capital, the way that we encourage people to make things is by financially rewarding them for making things. So, again, this is all dependent on the idea that we should have the concept of money and a division of property from each other. I personally disagree with this sentiment. I think everything should be the property of all humanity collectively, but certain things should be given, certain people should be given a slightly higher controlling stake in an object or a decision if it more directly affects them. But please go with me that it's a good idea that we should definitely protect intellectual property. I think we should protect intellectual property and discourage theft of ideas. I think idea theft is very bad. I think theft of property is generally quite good. You should steal things, kids. Except for the part where if I make something, the people who actually make money for it aren't just me. They're my bosses, and my boss's bosses, and their bosses. For instance, someone had to write "Let It Go," but the person who made the most money off of "Let It Go" wasn't the person who actually put the words to paper. It was some big wig at the top of the Disney food chain. However, it is important to prevent idea theft. So we should have a system by which if people make things, they should get to decide who gets to use them, sort of. It's complicated with ideas because ideas aren't tangible. If you invent something, someone else could replicate your invention using your plans and use it without your permission. Whereas if you make a good, say like you make a carved wooden duck, you obviously have to give that to someone or they have to steal it from you to acquire and use that duck. So we have to make up rules to govern why intellectual property is important. All of this should have been extremely basic. You already knew all of this. So people should not have their ideas stolen, actually. These were quotes that were written in my property textbook specifically about why we should protect intellectual property specifically. These come from the time of the founding of the United States of America. And indeed, in the United States Constitution, they specifically authorize the creation of a patent office, one that will keep track of different inventions that people have made. That's not something you should have known, but the general idea that like people should have the right to the fruits of their toil to make inventions is something that I feel very strongly that people should be given the fruits of their labor. And I would imagine that many of you do as well, but you already knew that, right? So there are four primary types of intellectual property. The first are patents. Patents are given to people who invent a thing. And yeah, that's basically what you need to know about patents. The thing about patents that's different from copyright specifically is patents you actually have to register. There are general requirements for three, sorry, four is copyright. There are three requirements for a patent. The invention has to be useful. It can't just be something that doesn't do anything. It has to be novel, aka new, and it has to be non-obvious. You can't try to patent a stick. You could potentially try to patent a trebuchet made from sticks and twigs. I think that would definitely be a useful, novel, and non-obvious patent. Not everyone can make a trebuchet like out of their head. So if you manage to invent a trebuchet with nothing but sticks and twigs, that's pretty impressive, and you would probably get a patent for it. In the United States, you generally get 20 years with a patent, and then you have to reapply. And if the patent office says that your invention is still not generic enough and it's still something they think you should have exclusive access to, they might grant you an extension on your patent. How do you get one? Well, with patents, you actually have to register. There's a specific US patent office. It also handles trademarks. You file paperwork with there, and a patent judge, who is a judge whose specific job it is to evaluate patents, will evaluate whether or not you should be granted a patent. And what a patent really means is you have the express authority of the United States government, and that grants exclusive use of your invention. You can delegate this use to other people. So you can allow a company to use things that you have patented with permission or for a fee. Patents are generally good. Patents are a good thing, and not a lot of people disagree with the fact that patents exist, unless you get to the idea that there shouldn't be a division of property, in which case that requires a little more overhaul, shall we say. The second type of intellectual property protection is the copyright. Copyrights are really interesting. The definition of a copyright in the United States Copyright Act is an original work of authorship fixed in a tangible medium of expression. This leads to an important definition. It says fixed and tangible. Those are the only two criteria for a work of copyright. It has to be fixed and it has to be tangible. If you, for instance, draw something on a table in Tabletop Simulator, sign it, and then take a screenshot of it, that is fixed in a tangible medium of expression. I think that's pretty rad. The coolest thing about copyrights is you don't actually have to let anyone know that it's your copyright. You just have to maintain the form of the original work of authorship. So as long as Dan, to just use a random example, still has a screenshot of the cat that he drew in Tabletop Simulator and one time and signed it, then he doesn't have to notify the US government that he has a copyright on it. If someone uses that artwork without getting Dan's permission, Dan is within his rights to sue. And I think that's also pretty cool. It's pretty cool that you don't have to let anyone know. You just have to maintain the original work in a fixed and tangible medium. That's pretty rad, I think. Trademarks. Trademarks are weird. You all sort of know what a trademark is. Think the Coca-Cola logo. It's distinguished, it's sensible, it's not functional. Trademarks can't do something necessarily. They're supposed to just look good. And that's generally what they are. There are two different types of trademarks. The first type of trademark is the common law trademark, which is, I have been using this trademark for a very long time, and no one else can use it if it might cause confusion. And then there is registered trademarks. Registered trademarks have the little R after them, and that means the government is going to be protecting your trademark too. And that's why you will see a lot more TMs than Rs, because the R's denote something that a corporation considers so worth protecting that they have applied to the government and told them in advance, this is going to be what our trademark is going to be for a very long time. And I think that's it. The last kind of intellectual property is trade secrets. And I'm not talking about this. So you might be thinking, how long does my copyright last? Well, I have a good answer for you. The entire lifetime of the author plus 50 years. Except, well, sort of. There's good reasons why it would go for the entire lifetime of the author. Like that seems sort of intuitive. As long as the original author is alive, you have a stake in the creations that you've made. That makes intuitive sense, even to a socialist like me. It also sort of makes sense that one could use a copyright to support their family or other loved ones after their passing. So 50 years, I tend to think that's a bit extreme. I tend to think that 50 years is wholly unnecessary. I think 10 years might be good enough, especially because certain works like Huckleberry Finn are technically public domain. And the only bad thing that has come of that is the Twain family doesn't get to currently profit from reproductions of Huckleberry Finn, which means that publishers can publish Huckleberry Finn and they just make it. They don't require permission from anybody. So 50 years is a rather long time to grant exclusive control, which is why in 1976, Congress extended it to 70 years. It was in response to the Republican Party getting bought out by large corporations. For the record, the Democratic Party is also bought out by large corporations, but the Republican Party doesn't even try to hide it. And I actually do consider that worthy of additional score. Additionally, the extension of the Copyright Act was challenged in court, and the Supreme Court says, yeah, it's totally fine. I tend to think that the Supreme Court are all bastards. And you should too. And if you want to know why, I can totally explain why. Or I could just recommend you listen to a podcast called 5-4 that's done by 3 actual lawyers who are also actual socialists. Congress realized that in 1998, Congress realized that the lifetime of the author plus 70 years is not the right amount of copyright, which is why in 1998, they extended it essentially indefinitely. Basically, they said at 1998, nothing is going to go public domain until January 1st, 2019. Everything is immediately getting extended by 20 years, and it could be even longer. We don't know, and we don't really care. This act that got passed was given another name called the Mickey Mouse Protection Act. I bet you can guess why. It's because Disney paid for it to pass. Hey, good news. Mickey Mouse is going public domain in 2024 until Congress extends it. And they will, because Disney has all the money in the world. Hey, question time. Question time. That means I am going to go check in. Okay. Crab Gang Cop Killer asks, do we get extra credit for theft? Yes, you do get extra credit for theft. Thank you very much. That's all that I have available. Does anyone have a question that they would like to vocalize? If so, Sam, you could go ahead and unmute them and just ask questions, and I will go get myself some water.
Hello,
and
students.
Be available
This is
to
Principal
take
Samuel speaking.
for the next
I am
minute
both
or
the
so.
principal of Jastalos University and the editor of these lecture videos. During this lecture, I spoke quite a bit. However, my audio during the lecture was lost in editing. I've edited around this as best as I can, but this particular moment deserves some voiceover. I asked Professor King about a lawsuit regarding Sherlock Holmes's character in later novels still being copyrighted. that allow the estate of Sir Arthur Conan Doyle to sue Netflix for their show Enola Holmes. I did a bad job of describing it during the lecture, and I don't want to repeat the same mistake. So, linked in the description of this video is an article that explains it better than I can. All right, thank you.
I would say that that's actually a really tough question. No wonder that suit was not immediately resolved with a settlement. Both sides definitely think they could win. I will say that, well, that's very interesting because 2020, January 1st, 2020, is when the last Sherlock Holmes stories go out of public domain. So the fact that they are producing this and planning to release it after the works go into the public domain is, I think, a very sound business move on Netflix's part. I will also say that this is because I actually know shit about Sherlock Holmes, but the I think the turning point where Holmes became less of an open and unrepentant misogynist was a Scandal in Bohemia, which is a work that is in the public domain. So I think that the answer is that Netflix can get around any of the arguments being brought up by Netflix can definitely, like with a good lawyer, can definitely get around any of the arguments being brought up by the Doyle estate. I think eventually Netflix is probably in the right here, specifically because these works, the last of the Holmes stories enters public domain in 2020. And because of that, I am inclined to believe that these works will be considered public domain because what will matter is not time of announcement, but time of dissemination of the work. So if it's planned to be released in September 2022, then I think that that will be the time that the work of authorship is done. It's releasing this September 2020. Oh. I will go ahead and say that finally, personality traits aren't copyrightable. A personality trait isn't fixed in a tangible medium of expression. Personality traits are things that can be exhibited by anyone. And while I will think that not being a misogynist was in short supply until, well, it's still in short supply, actually. Who am I kidding? But I will go ahead. Sophie has another question. Brilliant. Sophie, what's your question?
Is there anything we can do in the way of legal action to stop the imminent death of Adobe Flash, thus destroying millions of works of art across the internet? Is there anything we
Uh,
can do about that?
Legally speaking, no. Does that answer your question?
Yeah.
Illegally speaking, there's a lot of things that you could do, but then again, it would involve creating something that emulates Flash in HTML5, which is something
Hmm.
that is very definitely possible. It's just also very difficult.
Gotcha.
And also definitely in a legal gray area.
Okay. I know there's like a project to archive as much Flash content as fucking possible out there right now, but
I hope they've
yeah,
archived Homestuck. I genuinely hope they've archived Homestuck because
I would
if
imagine
that
so.
if that work becomes unreadable in its original form, I will be very upset. Because as good as watching the YouTube video of Cascade is, it's nothing like watching it on Flash for reasons that will only make sense after you've seen Cascade. We ready to move on? So I've mentioned fair use like once, I think, so far. So what is fair use? Uh, Basically, because copyright and intellectual property in general is designed to encourage rather than discourage people to make things, there's a limited suite of uses that is considered fair. Like you're allowed to use this, even if it uses a substantial portion of a work. For instance, you are always allowed to report on something. Newspapers can absolutely publish photos of works of art. They can absolutely do that. The press and stuff that is specifically for the dissemination of information is absolutely allowed. It's totally chill. You're cool. Parodies are a very, very common thorn in the side of people who make works of art, because many people do not like their work being parodied because it makes them feel like their work was wasted or like people don't like it. But parodies have to be fair use. They basically have to be. If we're discouraging parody, we're essentially limiting what speech people are allowed to make rather than simply how much speech people are allowed to make. If people aren't allowed to say that something sucks in a snide way, well, that's bad, and that's why parodies should and are fair use. There are 4 factors for fair use: the purpose and character of the use, including whether it is for nonprofit educational purposes or whether it is for commercial purposes. For instance, if I were to use a picture of a work of art in this presentation, say like 3 different pictures of therapy pipe, one couldn't say that Andrew Hussey could sue me for this, right? Like that would be ridiculous. That would be ridiculous. So instead, we consider the fact that this is a nonprofit educational use, that there is no way for me to make any money off of this, and just be like, well, yeah, it's cool. It's totally cool. It's not totally cool. There are 3 other factors you have to meet, but being for a nonprofit use is a big tick in your favor. The second is the nature of the copyrighted work. If Homestuck is a webcomic, if I made a book that republished all of Homestuck, that's bad. That would be bad. If instead the copyrighted work that we're talking about is like a story, and I disseminated an audio form of that story, that is suddenly a lot better. It's not necessarily perfect, because if it's a for-profit thing, then it still could fall under if it's a for-profit thing, then it's probably not gonna fly. But if it's like a non-profit, like someone wrote this fan fiction and I'm going to voice act it and disseminate it for free, or make an audio book of a recently released book because it needed to get made, that's generally considered fine. This sort of ties into the idea of a transformational use, where you take the original work and you make something different out of it, like fan fiction or something. Here, I'll go ahead and shout out the Organization of Transformative Works, who is more famous by their pen name Archive of Our Own. The Organization for Transformative Works does more legal advocacy than basically anyone, and they do it for fan fiction, and I love them for it. The Organization for Transformative Works has worked extensively with other organizations like the Electronic Frontier Foundation to protect fair use and intellectual property from people like Adobe or Microsoft or J.K. Rowling. And those people are generally not people I want to be able to take down works whenever they like. The third nature is the amount and substantiality used. If I copied a monster design from Monster Hunter, random example, say the Jastalos, and put it in my game, that would be bad. Does the Jastalos have horns? I have no fucking idea. What's like a notable feature of the Jastalos? Or if I gave something bug-like wings and lightning powers, though, without copying the entirety of the Jastalos, it would almost certainly be fine because we're not taking very much. Even if the idea was originally inspired, if you don't take very much, then the use is generally considered fair. And the last factor is the effect of the use on the market. Boy, do I hate this one. I absolutely hate it because people can claim so much damage from lost market potential if a parody is successful. Like, if a parody is successful and people appreciate it, oftentimes the author of the original work will go ahead and claim all of that as lost revenue. That's ridiculous. That sorry, that is that's a bit of a stretch for me. I would say it's a bit of a stretch. So I don't particularly like this factor, but I suppose it would make sense if someone like developed a drug and then someone else copied that drug. Then I suppose the effect of the use of the market would matter. But that's also something that more falls under trade secret law, and I really don't want to get into that. Speaking of fair use, do you know who Demi Moore and Leslie Nielsen are? Because I have a thing. Leibowitz v. Paramount Pictures Corp. Leibowitz v. Paramount Pictures Corp. Stemmed from two separate photographs. The first was a photograph taken by Annie Leibovitz. It's a very famous photograph. It graced the cover of Vanity Fair and features a pregnant, nude Demi Moore. She's gorgeous. She's absolutely gorgeous. This is specifically about Demi Moore embracing a new era in her career where she is supposed to be not just like a sex goddess, but a mother because she's pregnant. And it's a really good photograph, like genuinely beautiful. Mostly because Demi Moore is genuinely beautiful. This photograph is extremely famous. It was like the Kim Kardashian giant ass photo of their time. A year later, Leslie Nielsen starred in a movie called The Naked Gun, 33 and a Third, some subtitle that I don't remember. And one of the movie posters was this. Yeah. Annie Leibovitz did not like that her photograph was being parodied in this way and sued. And the Second Circuit Court of Appeals ruled in favor of Paramount Pictures Corporation, saying that no copyrightable aspects of the Demi Moore photograph appear in this one because you can't copyright a pose, you can't copyright nudity, you can't copyright pregnancy, and you can't copyright lighting. And so the only thing you could copyright is Demi Moore's face, or I guess her body in general. But this photograph was specifically staged with a different model who was not Demi Moore. That is not Demi Moore in the Leslie Nielsen photograph. That is a different model, and then it has Leslie Nielsen's face photoshopped on top of a model who is not Demi Moore. So the Court of Appeals held that this is a fair use parody of the original photograph. I think this decision was rather rad. I agree with it, even though it favors a corporation over an artist. Sometimes it's important that you put the right principle on paper, even if I would rather have seen Annie Leibovitz walking away with a lot of money than Paramount Pictures Corp. walking away with a lot of money. That should be that about that. Hey, pop quiz. We are going to be looking at some stuff and deciding whether or not it is fair use. So I am now going to show you something. I will give you 1 minute to think while I refill my water, and then I will call on someone who will tell me whether or not they think this is fair use. Mr. Dankbar, I am going to call on. Okay, there are 6 of you. I am going to roll a d6. 2. That is Sophie. Hey, Sophie. Do you think this is fair? Oh, sorry. Yes. I would prefer an explanation. You don't have to do a rigorous analysis of the 4 factors, which is what a lawyer has to do or a law student has to do. But just like, give me a general idea of like what you think the most relevant like things to take into consideration are. And I did call on Sophie because I rolled a 2. So, Sophie, what do you think?
I'd say fair use. I mean, it looks like something that someone made in Photoshop, and it's obviously not a physical product. It's just haha, funny meme, Mr. Dankbar. Like, it's not an object that's being sold. It's parody. Those are my thoughts.
What if I
It's a
told you that
graphic
you
someone
could
made.
buy a Mr. Dink bar? It's weed chocolate. It's an edible.
Interesting. Um, First off, my apologies to Mr. Dankbar. Didn't mean to insult him like that. Hmm. Um,
Sophie, have you had a dank bar?
God, I fucking wish. Um,
Would someone else like to come in for a rescue?
Help. I might know, but I'm not sure.
That's a 3, which means it's Jenna.
Yeah, hello. So I think given that it's a commercial product and that it also uses a substantial amount of the original, including like the general formatting, the exact colors, and the word Mr., I think it's probably not fair use. On the other hand, you could make the argument that an edible is not going to take much market from regular chocolate.
Yeah, no, that's a really good point. These 2 products are clearly not market substitutes for each other, which is definitely something that the lawyers for Mr. Dankbar are going to take into account if they ever get sued by Hershey. I don't believe that Mr. Dankbar has ever been challenged in court. I have seen a Mr. Dankbar. I have never consumed a Mr. Dankbar because it has peanuts in it and I would die. I think that there are really good arguments on both sides for whether Mr. Dankbar is fair use. It's really complicated, and I don't want to do a full 4-factor analysis right now, but I could definitely make, I think, a pretty convincing argument for why Mr. Dankbar is fair use. But I think overall, it's just a little too strong. While it doesn't actually provide, there's no actual chance of confusion. Like you're never going to confuse a Mr. Goodbar and a Mr. Dankbar. And it's not a market substitution in any way because it's an edible and it's only available for people who are 21 plus, which means that the market is also substantially smaller. It does use the general styling. I would say that if I were the judge in this case, I would rule in favor of Mr. Dankbar because I feel very strongly that parodies, especially obvious parodies, should count as fair use even if they are commercial works. A commercial work isn't necessarily excluded from qualification for fair use because it's a parody. I actually have a citation for that. It's Campbell v. Acuff Rose Records, which was a 1994 Supreme Court case where a parody of Roy Orbison's Pretty Woman, a rap parody of Roy Orbison's Pretty Woman, was held to be a fair use parody of the original Roy Orbison's Pretty Woman, because that and the title is all it parodied, and the rest of the song consisted of very different material. More than anything, I really appreciate the fact that, Jenna, you went pretty in depth. That's a good law student answer, because you answered with your gut and then also said, but on the other hand, and explained a very good reason why it would be fair use. Definitely extra credit for Jenna. Also, extra credit for anyone who so far has stolen something in the time that this presentation has been going on, because I did promise extra credit for that. Enjoy cock. So I am going to roll once more. 6. A 6 means Jacob. Jacob, do you think this is a fair use parody of the Coke logo?
Okay, so I must inform you, Professor, I am legally blind, seeing as I cannot see this screen. And I do not know what the logo that you are currently showing is.
It looks like the like Enjoy Coke logo, but instead of saying Coke, it says cock. It's a very fanciful rendition of the word cock with enjoy over it, and it's clearly styled to look like a Coca-Cola logo. I'm happy to post the image in chat if you want.
It might just be a Wi-Fi thing, but I'll just go with the narrative that I'm legally blind in this current lecture.
I totally understand. Do you wanna pass it off to someone?
I think I can go off of the description that you went, and as well as the image that has been posted for me. I would say, for a very legal standpoint, that this here image of this enjoy cock thing here is a very clear idea of parody. It's one that would, in a legal battle, seeing as depending on the, what's the word that I'm looking for here, the motives of the owners of Coke, their motives in regards to things, whether it be to earn money of any sort, what have you, they would have grounds for a legal battle against this because of the very, very close similarities to their own, just their brand,
Absolutely,
their brand, and their slogan. But it's very clearly to anyone with half a brain that this is parody.
Yeah. Being parody doesn't necessarily being a parody doesn't necessarily make it fair use, but I agree that this is a very clear example of fair use. I think Coca-Cola would probably challenge this in court if like someone like posted this up on a billboard or something. I don't think they would win, because this is a very obvious parody. It's not for commercial use because it's not promoting any product. It uses a substantial portion of the original work, but parodies are specifically allowed to use a substantial portion of the original work. It doesn't have any effect on the market for Coke, because people who were already going to drink Coke don't see something that says enjoy cock in the style of Coke and immediately decide, oh, I'm never going to drink Coke again. Like, that's ludicrous. That wouldn't happen.
Exactly. Yeah.
So I think that this is fair use. Yeah, very good answer, Jacob. Thank you.
Thank you.
We're getting to the end of the slides. Is parody good? Yeah. Yeah, holy shit, yes. Oh my fucking god, yes. Please, we need more of it, not less. We need to encourage works of parody, because parody is a form of criticism that doesn't a platform or civility, because, well, it's a parody. I don't really know how to explain this. Parody is extremely important for like critiquing art and modernizing other works of art. And I generally think that people who are closer to our age than our parents' age are much more likely to believe in strong protection for parody and other transformative works such as fan fiction. And I think that is genuinely a good thing. I think it's a good thing that those kinds of transformative works would have strong legal protection for them, because it's how people express themselves when they are not given a platform to criticize works more directly. Questions 2, the sequel to Questions, with a typo in it. I didn't realize it had a typo. Are there any questions? I will then take a look in Talking Stick. What's the question?
So, kind of a weird question, I guess. Like, if, I don't know, like, if, let me think. At what point, like, is parody not able to hold up in court? Like, if someone changed, I don't know, like, the Coke symbol to "I fucking hate the gays," like, at what point does, at what point does parody not hold up anymore, I guess? I don't know if that makes any sense
Yeah,
at
it's
all.
not a clear, it's not like a clear and definite point. Basically, parody has to go through the 4-factor analysis, the same as any other thing. Basically, you evaluate whether a parody has the correct purpose and character. You have to take into account the nature of the original work. You have to take into account how much of the original work is copied, and you have to take, regrettably, into account the effect of the use on the market. I can say that parody extends pretty far. There's a famous example of I don't remember the name of the play. I think it's like Who's Who, where it's a sequel. It's a parody sequel to The Grinch Stole Christmas, wherein a 40-year-old Cindy Lou Who chain smokes and talks to the audience about the awful sexual experiences that she had in the wake of the Grinch stealing Christmas and returning it back. Not awful sex like any assaults or whatever, just bad sex that she had in like on Christmas in the next years celebrating the return of Christmas. Yeah, it features a chain-smoking Cindy Lou Who and a Grinch who shows up for one scene. That's fair use. So the answer is it goes pretty far, actually. Fair use is pretty powerful. But I think the answer you were looking for is better answered by another thing, which is it's basically up to the judge. It is straight up to the judge in so many circumstances. Judges have enormous power, especially federal district judges. Federal district judges handle so many cases, and some of them are essentially decided on the whims of the judge. And we're all just okay with that because we confirm judges in the Senate, which is an undemocratic way to confirm some of the most powerful people in the country, if you ask my opinion. Judges are very powerful and can decide exactly where like a parody is no longer fair use, basically. Luckily for us, judges seem to be generally trending toward parodies are fair use, even if they are commercial. And just because a parody is bad and vulgar and offensive doesn't mean it's actionable. Does that answer your question? Yeah. Yeah, I could provide some more examples like in private, because I do have this. I have all of my notes from law school, and I did my my appellate brief, wherein I argued in front of an actual judge specifically about parody law. If you want me to go over some of the cases in which like parodies were held to be legal and where they weren't, like we can talk about that. But I can't really like comb through my notes right now. So I am super happy to continue this call later though. Or not this call, but like this question, because this is a very, very close to my heart topic of what does a parody have to do to go too far? so it's no longer considered fair use. Thank you so much for your question. That's a very good question, and it's a very difficult one to answer correctly, if that makes sense.
Yeah. Thank you.
Thank you, Sophie. Are there any other questions? Jacob, what's your question?
Make its own individual work. Can I do that? Because I want the original creators to acknowledge my genius, or at the very least that I'm good at writing.
Okay, so there are two parts to this question. Can you do that? Abso-fucking-lutely. What do you think Twilight is? Or sorry, what do you think 50 Shades of Grey is? Fallout Equestria, a My Little Pony fanfiction, is now published as its own separate work, and you can buy it. The Homestuck epilogues started as an extension that was briefly outlined by Andrew Hussey and then turned into someone else's project and problem. And I have that cursed tome right next to my face right now. The answer is yes. The second in the opinion of the Organization for Transformative Work, the second you commit a fan fiction to paper, it becomes an original work. It's also a fan fiction, but it becomes an original work. The second part of your question is because I want it to be recognized by the creators. I will say the creators of the work for which you're writing fan fiction want to read fan fiction of the work they're making, but usually they're legally not allowed to. The author of the novel Gideon the Ninth, Tamsin Muir, has stated openly that she desperately wants to read Gideon the Ninth fan fiction, but can't because she is not allowed by her publisher to read any fan fiction until she has submitted all of the manuscripts for her series. Because they don't want to get sued for possibly stealing ideas. And so to do that, they cut off the author from being able to read derivative works. The creators of the work that you're writing fanfic for want to read your story, but they might not be able to. And I'm very sorry about that. But once they stopped, they might actually read it and like it. Does that answer your question?
Yes, it does. Thank you very much.
Of course. It's perfectly acceptable. It's perfectly acceptable, sir. Are there any other questions? I'm checking Talking Stick right now. Question from Sophie, aka Crab Gang Cop Killer. So is Jacob protected by the I can write Ruby better than you can law, a justified law? Legally speaking, most people can write Ruby better than Rooster Teeth. Look, I know for a fact that many people prefer the works of fans like ending a series to the works of the original creators ending the series. For instance, the Homestuck epilogues, which I have in my hand, which were outlined by Andrew Hussey, but not written by Andrew Hussey, except for the first little bit of it, which was written by Andrew. Anyway, yes, Jacob isn't protected by a literal law which says Jacob can write Ruby better than Rooster Teeth, but Jacob is protected by copyright law. And the Organization for Transformative Works is fighting for that right desperately because they have a lot of stake in being able to maintain AO3. I am going to allow questions for around 30 more seconds because my lecture's done. Thanks. Thanks so much. If you have questions, just hop in chat. Thank you. I know it wasn't as funny as the FNAF lore lecture, but I do hope you learned something that might actually be valuable. Learning about the law is I think it's a skill that non-lawyers should have. And also, those of you who spoke today displayed a lot of ability to like think critically about the ideas that I'm presenting to you. And I want to give you a hand for that, because that's not easy. Speaking up and sharing something can be intimidating, and I'm really proud of you for sharing your opinions. That's the end.